SJC-12442, Commonwealth v. Jose Nascimento.
Thanks. Good afternoon, Ms. Saxey. You may proceed, thank you.
Thank you, Your Honor. Good afternoon, and may it please the court, Helle Saxe on behalf of the Commonwealth. With me is ADA James McGee, who opposed the motion in the trial court. We're today asking the court to reinstate the portion of the complaint that charged the defendant for OAS after OUI in violation of Chapter 90, Section 23, third paragraph. And the issue before the court here is whether a defendant can be charged with OAS for OUI if his license is administratively suspended for failure of a breath test and the OUI case is pending under Chapter 90, Section 24, 1A. Section 23, third paragraph, applies to licenses suspended or revoked pursuant to a violation of Section 24, 1A, or pursuant to, for example, Section 24D, Section 24N, and others. And that language includes both pre-conviction suspensions as well as post-conviction suspensions.
Where does it say that? Where does it say that?
Because Section 24N is a pre-conviction suspension upon arraignment, and Section 24D or the others are G and L are all post-conviction license suspensions.
But I mean, I appreciate your argument that it would have been wiser for the legislature to have done what you say, but the issue before us is whether it did. And 24A1 does have, I know does not speak itself of suspension or revocation, but 24(1)B does say upon a conviction under 24A1A, then you will have your license suspended.
Exactly, and there lies the distinction because, as you said, 1A does not talk at all about suspension or revocation, and so the court has to look beyond that. And where Section 1B talks about a conviction of a violation, that is different from simply a violation. And we're arguing that, therefore, the suspension and revocation pursuant to Section 1F, 1 and 2, is likewise included in the violation of Section 1A.
But it's not a finding of a violation. It's a police officer getting a breathalyzer test result and acting upon it. In order for there to be a conviction, you would have to come to court and you would have to litigate it, and the jury would have to find that the breathalyzer result was accurate. And Lord knows we've had cases challenging breathalyzer results. So why does the police, the determination by the police officer become a finding of a violation that the legislature can act upon?
Your Honor, it is more than simply the action of a police officer. The revocation under Section 24(1)F is, of course, required, but in addition, there is a requirement that a magistrate find probable cause that a defendant indeed committed OUI. So Section 23, third paragraph, does not apply unless you have those two components, a revoked license and a pending case that is pending on the grounds that there is probable cause to believe that someone operated under the influence.
I still don't understand why you don't need a conviction, the OUI conviction.
Because a violation of Section 24(1)A does not say a conviction of a violation.
Isn't that how you find out if someone actually violated it? By the person being convicted of it?
No, Your Honor, because the license, the automatic license suspension upon either failure of a breath test by blowing over a .08 or refusal to take a breath test, those administrative revocations would be entirely meaningless if they didn't have any consequence for someone who then chooses to still continue driving despite the fact that his or her license has been suspended because they were subsequently charged in court with operating under the influence.
Well, they'd still be they'd still be operating with a suspended license. They'd be charged with that.
But the keeping in mind that driving in Massachusetts is a privilege and not a right, the legislature meant there to be a difference whether your license is revoked because you failed to pay a parking ticket or because a magistrate determined that you were operating under the influence.
There's a general operating after suspension statute if I don't pay traffic tickets and the like, correct?
Yeah.
But we're not dealing with this. Now we're dealing with the, as Justice Bud indicates, the higher penalty, the minimum mandatory, correct?
Correct. Yes.
So if a police officer pulls me over and I refuse the breathalyzer, I get bailed out. I'm arrested for OUI, I get bailed out. In the morning, I drive to court with the police officer having my license in his or her pocket. I get pulled over by the same police officer who's not too happy that I'm driving to court. I can be, under your scenario, I can be arrested, charged with the minimum mandatory under Section 23, correct?
Yes, Your Honor.
Under your sister's scenario, I can only be charged with the less severe operating under after suspension.
That is correct. And one more distinction I would like to point out to the court is that Section 24, capital N, is explicitly enumerated in Section 23, third paragraph, as one of the triggering mechanisms for that crime. And that involves a judge in court to take away someone's license in the event that the officer at the scene failed to do so.
But you know, that the defendant is saying there's some judicial oversight before that license gets taken, as opposed to the police officer in the station or on the street taking the license, and that the legislature must have thought that important, or they would have included 24 1A in Section 23.
Your Honor, that is a valid argument, but a close reading of the statute indicates that the safety mechanisms, so to speak, in 24N and those in 24(1)F are very similar, if not identical. In court...
So if that's the case, why didn't they just include 24(1)F in the provision? I mean, it would be so simple if they did that, but they didn't.
Because 24(1)F on its own is merely the taking away of the license. It is not the OUI charge. The legislature wanted to, let me back up. The 24N takes place at arraignment. It assumes that someone is actually being arraigned for OUI, and the judge takes away the license upon a prima facie showing of refusal of breath test or failure. And that prima facie showing consists of a written statement by the officer, which is a certification saying that he's properly trained to administer breath tests, that the machine was working properly, and that the test was correctly done. That is being signed, and if that is handed to the judge shall revoke the license. There really is no discretion at the hands of the judge when that occurs.
Well, 1F2 calls it a suspension.
Yes, but 24(1)F also requires an officer who suspends someone's license at the scene of the OUI stop to then file a report with the Registry of Motor Vehicles on signed under the pains and penalties of perjury, certifying exactly the same things that he or she has to certify under 24N.
So then maybe it makes no sense to have 24N within Section 23 and not have 24(1)F. Maybe it makes no sense, it's not good policy, but you know, as far as the rule of lenity and statutory interpretation, for whatever reason it might be, inadvertence or a policy decision, it's not there.
Your Honor, 24(1)(f) does not spell out the crime of OUI. And Section 23, third paragraphs requires the automatic revocation of the license plus the complaint for OUI upon someone has been arraigned and which is pending, or upon which someone has been convicted, obviously, but in these circumstances, a pending complaint. 24N encompasses the arraignment for OUI plus the license revocation at the hands of the judge. And that statute is, in the way it functions today, older than the mechanisms of 24(1)(f) that are in place today. Because 24(N) has been, I believe, in place since 1986. 24(1)(f) today operates automatically because the breathalyzer results and the license revocation that goes with it are electronically communicated through the breathalyzer machine. That didn't exist in 1986. So I think now 24(1)(f) revocation has sort of overtaken 24(N), which used to be the primary mechanism of taking away people's licenses upon
Maybe the
OUI.
legislature should have kept up with that then.
Well, they should, but the way the statute is written, where you do need a complaint, you need a violation for OUI. There's no charge under 23, third paragraph, if there is no complaint for OUI. But a license could be revoked, for example, automatically at the scene, and then it turns out that the event actually did not take place in a public way, and there will never be an OUI complaint.
But going back to, well, let me step back. 24(1)(a) requires an action by a court, which would be a finding by a court, correct?
24(1)(a).
Right.
Yes.
24(d) requires court action to suspend. I think it's person for a person convicted or charged, it would be by probation.
24 capital D.
Yes.
Yes, Your Honor. Yeah.
24(e) requires court action.
It does.
24(g) requires court action.
That's upon conviction, yes.
24(l), does that require court action?
Yes, it does.
And 24(n), you've just said requires court action.
Yes.
So the only one that does not require an action by a court but can be done by a police officer alone is 24(1)(f).
Which can never stand on its own. It is intrinsically linked to 24(1)(a).
You say that, but let's go back to poor Justice Gaziano's circumstances. You just said that he would be in violation, but he's going to court. He's not had a finding of probable cause made yet. Why do you say, 1F is a suspension upon, if it happens to him, he's suspended as of that moment.
Your Honor, I may stand corrected. If the driver had only been arrested and no complaint for OUI had yet issued while the violation of 23, third paragraph occurs, then it probably would not apply.
But I
But
think,
the police officer, I refuse the test, and then he, on behalf of the registrar, and I'm reading from 24(1)(f)(2), gives me a written notice of suspension, and they take my license. They have to do that.
Right.
Now he has told me, your license is now suspended, and he reports me to the registrar. I'm operating after suspension because he took my license.
You are. But if
When I
you're
drive
on
to
your
the
way to
courthouse.
court
Yep.
to be arraigned for OUI, you're not yet in violation in the sense that the complaint may not have yet issued, you probably have not yet been arraigned for OUI, and therefore in violation of 24(1)(a) does not
But then
yet apply.
after I'm arraigned, 24(n) kicks in.
No, I think that is a simultaneous process. And 24(n) will
So
never,
so I get arrested driving out after arraignment.
after arraignment is different than before arraignment, yes.
In this case, obviously, it was after arraignment.
About 3 weeks, yes.
Right.
How many times does section 23 been amended in the last 5 years, roughly?
Oh, I'm not sure I can answer that question. I think there was a significant amendment in 2005, but the section we're arguing about, I think, has remained more or less the same. And the main reason we're here today is because we're simply seeking clarification, because even within Suffolk County, these cases are treated differently by different judges, and defendants are therefore treated differently, and we just can't have that.
Counsel, are there any other statutes in your research that you came across that had that language, conviction of a violation?
I can't say off the top of my head. It certainly is in section 24(1)(b), and I was just reading case law. I think the term "in violation of" is commonly used by the courts, by the Commonwealth, by any litigant to signify probable cause or, based on a complaint or an indictment, and a conviction on a violation, therefore, has to be different, has to mean something different.
All right, thank
The court has no further questions. Thank you.
you. Ms. Dale, good afternoon.
Good afternoon, Your Honors. May it please the court, Shannon Dale on behalf of the defendant appellee Jose Nascimento. Your Honors, the issue before the court this afternoon is simply whether the defendant, Jose Nascimento, by failing a breathalyzer test, can properly be charged with violating Chapter 90, Section 23, and therefore be subjected to a mandatory minimum sentence of 60 days, prescribed by 9023. I think the crux of this argument, Your Honors, is that we simply need to look to the plain language of the argument. If the legislature wanted to include this provision, that provision being 9024(1)(f), 1 or 2, it would have chosen to done so. And I think that the legislature's silence on this matter, given the amount of times that the legislature has amended this statute, 9024, I think is worth noting. I think also that this statute is not ambiguous. This simply is not an enumerated provision, that provision being 9023(1)(f). And therefore, if the court doesn't find the statute to be ambiguous, because it is a criminal statute, the rule of lenity should apply here. The defendant should be given the benefit of the doubt of the ambiguity, and therefore he should not be sentenced to the mandatory minimum 60 days. I think, and this is cited in my brief, that to deny that a violation is synonymous with a conviction would be to deny the defendant the presumption of innocence.
Well, not all of them require a conviction. I believe that 24D can be done for a person convicted or charged with a violation, but the person is placed on probation, maybe pretrial probation, but it does provide for something before a conviction.
That's correct, Your Honor. However, I think in this case, in the defendant's case, Mr. Nascimento failed a breath test. The failure of a breath test on its own is not per se evidence of a violation of a statute. In order to violate a statute, you need a conviction, and a conviction is only proven beyond a reasonable doubt.
But I mean, certainly if he had gone to court and the judge under 24N had said, I'm going to invoke it, you wouldn't be here, because it can happen without a conviction as long as it's done pursuant to one of these statutes. And
to answer Your Honor's questions, I think that there are certainly some reasons why 24N was included as an enumerated provision. 24N, of course, as Your Honors know, is a process that's done in court before a judge. There are more due process protections for the defendant. He has defense counsel standing next to him, advising him, hopefully, of the potential penalties that he may face. He has a judge in front of him, that judge being a neutral decision maker. This is a much, much different scenario than what is contemplated.
What kind of decision-making takes place when the person refuses the breathalyzer?
I'm sorry, Your Honor?
Person refuses, I'll use myself, like, I refuse the breathalyzer, and I go to court. What kind of decision-making does a judge take into account, and I get my fine lawyer to give me representation, but I refuse a breathalyzer. Where's the decision-making?
So are we assuming that,
Under 24N, you said it requires, 24N is different in kind than the roadside or station house suspension of a license. How is that different?
well, I think, again, you have much more due process protections in court. You have a defense counsel by your side letting you know what can happen if you continue to drive after arraignment, or if you choose to drive after arraignment. I think it's very clear, or much more clear than the situation on the side of the road, where I think we can't ignore the fact that this driver, who an officer just determined there was probable cause to arrest him for operating under the influence, this driver might be intoxicated. So I think we have an issue of notice as to whether that driver understands what's going on and the potential penalties that can flow from his choice to drive again, versus a defendant who is in court standing next to a defense counsel with more due process protection.
If there's no penalty for driving after a police officer suspends you, why do we have this provision?
Well, I think there is certainly going to be a suspension if a police officer suspends your license. First of all, it depends what happens. If you fail a breathalyzer test, here, the administrative suspension is 30 days. You may have another suspension if the case is litigated and you get convicted. But that is under 9024(1)A, and that's just the simple OUI statute that prescribes the penalties and the fines that can flow from what can happen if you're convicted. Again, a violation requires proof beyond a reasonable doubt. It is.
That's why 24N is important, though, because 24N is within Section 23, and it doesn't require a conviction. So when you deal with a violation of 24, and when you look at a violation of 24, you're saying, well, somebody has a .08 or more breathalyzer. That's certainly probable cause that there's been a violation, and we know from Section 23 that a conviction's not required. That's the argument that I think is being made by 24N.
Yes, and again, I think, I don't think it's the job of the court to assume what the legislature meant. We have to turn to basic tenets of statutory construction. We have to read the plain language of the statute. There are multiple enumerated provisions under 9023, and 24(1)(f), 1 or 2 is not one of them. Again, this is a heavily scrutinized statute. The passage of the Safe Roads Act, high-profile passage of Melanie's Law. The legislature has looked at this statute multiple times and has chosen not to include this provision in it every time. I think that the legislative silence on this matter can't be ignored. And if there is some question of ambiguity, or if the court finds the statute to be a bit ambiguous, then again, this is a criminal statute. The rule of lenity should benefit the defendant. I think it's also worth noting that a first offense operating on a suspended license, the defendant can be subject to a maximum $500 fine. The Commonwealth now would seek to punish this defendant with a 60-day minimum mandatory jail sentence, which is a significant discrepancy.
Okay, thank you.
Thank you.